So starting with Supreme Court judgment in the case of Billerwood Chemicals. So in this case, the issue was with respect to interest rate on delay in granting of refund. So the assessee had filed for refund of export of goods. In that case, there was a delay from the department's side for 90 to 120 days in granting of refund. So the assessee approached for the interest rate. So the High Court allowed the interest rate at the rate of 9%, which was over and above the rate that was given in the statute, that is 6%. So the department filed appeal with the Supreme Court. So the Supreme Court has held in this case that wherever the statute provides for an interest rate for delay in refund, in that case, interest should be paid on the basis of the statute. So if it's 6%, it should be 6% only. In case the statute is silent on payment of interest or on the rate of interest, in that case, High Courts can pay the interest at reasonable basis on the equitable grounds. There was an interesting observation by the Supreme Court in respect of inordinate delays. So the Supreme Court said that even a statute provides for any interest rate, if there is an inordinate delay by the department in grant of refund, in that case, the High Court can choose to grant interest at higher rate. While we agree with the first two parts of the judgment, in respect of inordinate delay, we believe that since the statute does not provide for the same, it would be very subjective as to what amounts to inordinate delay. So in our view, whether it's a delay of 2 days or 2 years, the interest should be granted as per the statute rate only. The assessee would anyways be compensated for the time period, but interest rate should not be granted at a higher rate. Moving to the High Court rulings, so in this recent case of Calcutta High Court, this was a Tranvin matter. So the taxpayer was subjected to multiple investigations in respect of the same Tranvin. So earlier the CGST department investigated its Tranvin. Then the DGGI started investigations in respect of the Tranvin. And then the audit department audit wing also issued a spot memo. So the court held that none of the proceedings, either by CGST department or the DGGI, were taken to a logical end, and so the petitioner was dealt in a very unfair manner. So it quashed the memo. So in this respect, we would like to highlight that while the law itself does not put bar on the parallel proceedings, it only bars under section 62B for the parallel proceedings on the same subject matter by state and central. And in this case, these were central authorities only. So while strictly there is no bar, but as far as the settled jurisprudence in this regard is concerned, this is an unfair practice that on the same subject matter, different wings of the department is raising investigations. So to that extent, this ruling is correctly held that it should not be done to the petitioner. Moving to the Madras High Court judgment in the case of petrol explosives. So this was again the matter of Tranvin. In this case, the petitioner's factory had met with a fire accident due to which its factory was closed for about 2 years. And so it opened the business in August 2018 when the timelines for filing of Tranvin was gone. So he could not transit his credits. So the court, again, like many other matters, it held that because of technical difficulties, the substantive benefit should not be denied. And this was a very genuine difficulty for the taxpayer. So the court directed revenue to credit the amount in electronic cash ledger or grant the same value of electronic cash refund. While there have been many judgments in respect of transitional credit issues wherein high courts have been continuously granting relief or favorable judgments for the taxpayers, in this case, we would like to highlight that court has gone way beyond the equity grounds as well, because if it had to restore the taxpayer on the same position, it would have granted credit in GSTR 3B. But by granting a cash refund, they have gone even beyond the equitable grounds. Next is the case of ITEC Plus, a Gujarat High Court judgment. So this was a case of an inadvertently claimed refund. So what happened was the assessee imported inputs under advance authorization. So it imported inputs duty free, and then it exported the goods on payment of GST and claimed refund. Under Rule 96, then there is a specific bar that if you have imported inputs under advance authorization, then export cannot be made on payment of GST and refund cannot be claimed. So on realizing this error, petitioner repaid the refund along with the interest and filed for the refund of the credit utilized. So the department was denying, saying that there is no provision for the recredit of ITC. The court went on to the restitution principles and held that if the assessee has already repaid the refund, he should be restored to the original position wherein he would not have filed the refund. So in that case, the credit that he has utilized for the payment of GST should be restored. In our view, the judgment is correct because the taxpayer should be restored on the same position. While in our view, in this case, court did not refer to any provision in the GST law. Legally also, a taxpayer in such cases can file for refund because under section 54 read with rule 89, if any excess tax has been paid, that can also be demanded as refund. So in this case, it tantamount to excess payment of tax. So assessee could file a refund application also under GST law. Moving to next judgment, so this was a jurisdictional issue case. The petitioner challenged the show cause issued by a state tax officer as his jurisdiction was under central tax officer. The court held that under section 6, both state tax officers and central tax officers become qualified proper officers. So there is no inherent lack of jurisdiction, and the division of taxpayers is only done for administrative convenience, which is very well coming from the GST Council minutes, that this division is only for administrative convenience, and otherwise both the officers have the jurisdiction. So on this basis, the court held that the proceedings cannot be nullified even if it is raised by the state tax officer. In our view, the judgment is correct as both the officers have the jurisdiction and section 6 specifically provides for the same. So to that extent, proceedings cannot be nullified. Now moving to advanced rulings that have come up under GST. In a Maharashtra advanced ruling authority, the case went to the authority was with respect to incentives. So in this case, the applicant's original equipment manufacturer OEM was located outside India and it was receiving performance incentives from that manufacturer. The interesting part was that goods were purchased from Indian distributors of the OEM and not by the OEM itself. So SSC was claiming that it should qualify straight discount. However, the AR held that it cannot qualify straight discount because it cannot be related to the purchases, as purchases have not been made from the OEM. And so to that extent, if OEM is paying any amount, that would be considered as a consideration for supply of services. That could be marketing services. So to this extent, AR has rightly held that this will not amount to rate discount because you cannot establish the nexus with the purchases. The AR further went on to hold that place of supply of these services would be India under section 13(3)(a) because of performance-based services. So it held that marketing services are supplied in respect of goods made physically available by the OEM to the service provider. We differ to this view because for provision of marketing services, physical presence of goods is not a necessary element. So to that extent, it should qualify under the general rule and it should qualify as export of service. The next ruling was in the case of Crystal Crop. So again, this was an interesting issue. The assessee was merging two GST registrations. So it had registration in state A and state B. So it wanted to merge both the registration and state B. So it applied for transfer of credit through ITC 02. So applicant was asking if it can treat it same as the transfer of business and thereby supply of service and then transfer the credit through ITC 02. The AR held that since these are two distinct persons only and not another person, so it will not amount to transfer of going concern to another person. Hence, it will not be a service but a supply of goods. Further, in respect of transfer of credit through ITC 02, also the AR denied the transfer on the ground that merging two registrations of same legal entity will not change the constitution of registered person. In our view, the ruling is incorrect Because firstly, when the law itself deems two registrations of a person as distinct persons, so transfer of business from one registration to another registration would tantamount to transfer of business that you're both concerned. And secondly, change in constitution of registered persons should be read in a constructive manner. And even if the business is getting shut in a one state, it would amount to change in constitution of that registered person. So ITC should also be allowed to be transferred to ITC 02. Now coming to some other rulings, some CSTAT rulings. So as we all observe that even under GST or under service tax, the authorities are taking this report that basis the income tax authorities reports, documents, investigations, they are directly raising demands with respect to service tax or GST. There have been several rulings to this effect, and this was the one ruling CSTAT Ahmedabad, wherein the CSTAT has held that just pays the income tax documents, the department cannot raise SCM. They have to have their own investigation and reach to a conclusion to raise an SCM. Next is the case of CSTAT Ahmedabad in the case of Shell Energy. So in this was a case of unjust enrichment, and the topic of unjust enrichment is normally undermined by the taxpayers, but the courts have been consistently denying refund on the ground of non-satisfaction of unjust enrichment test. So in this case, what was happening was that the taxpayer paid the tax and created a receivable entry wherein it made the government as debtor. So as long as it created a receivable, it was fine. But correspondingly, it also created a provisional entry in the PNL to the effect that in case this is not recoverable, it will amount to cost. So the CSTAT held that by creating a provisional entry in PNL, ultimately you are adding on to the expense and the cost, which would become the cost of the product, and ultimately you will recover it from the customer, and so the unjust enrichment will get attractive. So it denied refund to the taxpayer and ordered it to transfer to consumer welfare fund. In this case, we would like to highlight that whether all these parameters as to whether you are creating a receivable entry or you are making a provision, etc., are indicative parameters, but the ultimate test is whether the tax burden has been passed on to the customer or not. So there is a Bombay High Court judgment wherein the taxpayer had expensed off the tax cost, and then also it proved that it did not recover it from the customer. It did not make part of the cost of the product. So in that case, the unjust enrichment test was satisfied. So while all these are indicative parameters, but the ultimately taxpayers have to prove through various evidences that they have not passed on the burden to the customer. Last ruling is with respect to what qualifies as inputs or raw material. So this was the issue where the department was denying credit on welding electrodes on the point that these are used only in the process of manufacturing but are not part of the end product, finished product. So the High Court referred to the famous Balar Industries Supreme Court judgment and held that it is a settled principle that whatever is used in the manufacturing process qualifies as raw material, and it does not have to have does not need to go into and be found in the end product to qualify as raw material. So in this case, the SSC was dealing in the manufacture of prefabricated structures. So welding was an inherent process that was required. So welding electrodes were getting consumed in that welding process. So particularly they were not forming part of the finished goods, but since it was an important essential element of the manufacturing process, so the CSTAT allowed this credit on welding electrodes basis the settled jurisprudence. Stay tuned for our next roundup in next month. Thank you.